It's the end of the quarter. You've got a mountain of compliance tasks to complete, daily requests from sales for security documentation, and an upcoming audit. You're waiting on evidence requests, and you can't find the policy you wrote last week. Compliance management is hard. Aptable Comply makes it simple. Comply is an end-to-end, purpose-built GRC platform to manage compliance. From automating evidence collection to integrating with your existing SaaS tools, Comply simplifies the hardest parts of managing compliance. Reduce manual processes and build trust with your customers. Visit securityweekly.com/Aptable to learn more. RSA offers business-driven security solutions that provide organizations with a unified approach to managing digital risk and designed to effectively detect and respond to advanced attacks, manage user access control, and reduce business risk, fraud, and cybercrime. For a limited time, get mobile multi-factor authentication from RSA Secure ID Access for free to help secure your remote or dynamic workforce long-term. Leverage push notification, biometric, and one-time password authenticators to secure access to your cloud applications, on-premises systems, legacy systems, privileged accounts, and more at no cost for 6 months. For more information, visit securityweekly.com/RSA Security. Did you know that over 63% of cyber breaches are caused by a third-party vendor? CyberGRX is on a mission to modernize third-party cyber risk management. Built on the market's first third-party cyber risk exchange, CyberGRX arms you with fast and accurate data, a proven and innovative approach, so you can make rapid, informed decisions and confidently engage with partners. Learn how partnering with CyberGRX will help you become cyber certain. Visit securityweekly.com/CyberGRX.
All rise, and welcome back to Security and Compliance Weekly. We're very excited for this segment. We were able to get Priya Chaudhry, who was on a couple weeks ago, back with us. And what we are trying to do here, what we're going to attempt to do here, and we'll see how it goes, is sort of play out, role play, have a mock trial, discussing a criminal case that on appeal has made it all the way to the Supreme Court, and it's focused on interpretation and scope of what in the hacker community we all love or hate, the Computer Fraud and Abuse Act, or CFAA. Scott and I are going to be the role of judges. I'll be the Chief Justice. I've got my official Jailbreak Brewing Company gavel, which is really a crab mallet. And we're gonna see how it goes. Let's get a few announcements out of the way, and then we will convene. So it's official. Security Weekly, in partnership with the Cyber Risk Alliance, is excited to present Security Weekly Unlocked, a unique digital event that will bring together the cybersecurity community for a full day of learning, innovation, and celebration. This is going to happen on December 10th, 2020, and coincidentally, we are doing it in conjunction with Security Weekly's 15th anniversary. Registration will open soon, but we do have a call for speakers currently open. If you're interested in speaking or to learn more about the event, go to securityweekly.com/unlocked. And by all means, please fill out the CFP to be a speaker. Also, Security Weekly is ramping up our webcast and technical training schedule for the rest of 2020. Our next webcast, you're going to learn how to reduce the blast radius of your cloud infrastructure. To register, you can go to securityweekly.com/webcasts. You can also see what else is coming up. And of course, for any previously recorded webcasts, you can go to securityweekly.com/on-demand. All right, court is in session. Today we're going to talk about the CFAA court case that's before the Supreme Court. Representing the U.S. government, we have the Honorable, do we call you Honorable? I don't know if you're honorable. John Snyder, Esquire, is going to represent the U.S. And please give us your opening statement and kind of explain what the case is all about. And then representing the respondent, who is representing the defendant in this court case, in this criminal court case, will be Priya Chaudhry. So we're all looking forward to watching John be put in his place by Priya. So, John, please proceed with your opening remarks.
Well, I'm taking the side of the government here, though I'm a little bit jealous because I kind of like the side of the defendant a little bit better. But it's an interesting case. The Computer Fraud and Abuse Act of 1986 was put in place in large part because of the movie War Games and how that brought to the public consciousness the risks of hacking. And as often is the case with criminal statutes, is they're written very broadly. And in order to know what the law really is, you got to wait and see what the courts do with it. And, in this case, we have a number of courts of appeals. There's 11 different circuits plus a couple others. And they've come out to different answers to the question that's presented here in this case. And so when the different circuits disagree, often the U.S. Supreme Court will come in and settle the matter so that all the courts know what the rule is. And in this coming term, which is going to start in October, the U.S. Supreme Court is going to decide the scope of the CFAA. And so I'll start with the actual language of the statute. It says that you're liable and you're guilty of a crime under the CFAA if you, and it's very important to get the words, it's very short, if you intentionally, meaning you intend to do it, access a computer without authorization, okay, fair enough, you've hacked in, or, and here's the language that is important, or if you exceed authorized access and thereby obtain information from a protected computer. What happened in the Van Buren case, which is the case before the court, is a police sergeant took a bribe, essentially, of $1,000, and to run a search of a license plate through the FBI database to find out if the owner of that car was a government informant. And there's all sorts of nefarious reasons why they were doing that. He was arrested in a sting operation by the FBI, and he was charged under the Computer Fraud and Abuse Act. Now, the police sergeant had a username and password for this database, was fully authorized to access it, but he was not authorized, and there were very clear policies that say that you can only use this for proper law enforcement purposes. In this case, he accessed the database to basically help a criminal, which was not authorized. And so they prosecuted him. He was found guilty. He appealed to the 11th Circuit, which is the circuit court for Florida, always Florida. And the 11th Circuit held that that the law covers not only hacking into a system that you're not allowed into, but also going beyond the scope of what you're allowed to do. So he was, if he was using that database for legitimate law enforcement purposes, would have been no problem. But in fact, here he was using it to help a criminal, and therefore it was a problem. He, meaning the defendant in the case, has taken the position that the only time you should be able to be charged under the CFAA is if you basically break into a system that you're not allowed to be in the first place. And Priya is going to take the side of the defendant, and I'll just sort of leave it with the observation that if the law is that you have to break in, and it cannot be a violation of CFAA if you merely exceed your authority or exceed what you're allowed to look at or look at it for an improper purpose.
I strenuously object, John. You should let Priya speak for herself.
Then in that case, Chelsea Manning could not have been prosecuted under CFAA. And surely Priya would not want that result. So I'll let Priya go from there.
So I'm going to start by saying I don't need to put John in his place. The Constitution will be putting him in his place, because if it is actually applied here, the 11th Circuit's interpretation of the law just cannot stand. So what we're talking about is a statute that is an anti-hacking statute, meaning there has to be a hack. And as you all know, listening out there, that means you broke into someone's computer system. The first part that John described of the statute is outside hackers. We all know what that looks like. Someone breaks into your email from the outside and starts sending out emails pretending to be you. The second part of the statute is for inside hackers, meaning someone who was allowed into your computer, but then broke some sort of metaphorical lock in order to exceed where they were allowed to go. So the analogy would be you invite a contractor into your home, but you've locked things into a safe, and that person then broke the lock on the safe to get in there. So the person had permission to be in your house, but didn't have permission to do the thing that they did. So that's what this statute's about. It's an anti-hacking statute. All of the things that happen with the information that was gotten can be proscribed, meaning rendered illegal by other statutes, and is rendered illegal by other statutes that are clearly written. And the reason I say that the Constitution is what's going to put, hopefully, John and the government in its place, is all criminal statutes have to be understandable. They have to be enforceable in a predictable way. And most importantly, they have to be read in a way that doesn't make everyday behavior by everyone criminal. And so that's where we run into trouble, because the way the 11th Circuit has interpreted this is to remove all of the hacking. So they don't care if you hacked or not. They don't care if you broke into the part of the computer that you're in. All they care about is, did you violate the terms that you were authorized to use it for? Now, this is where the briefing below by the NACDL, which is the National Association of Criminal Defense Lawyers, and the implications encapsulated that are so important, because if you read the statute the way that the 11th Circuit reads it, anyone who is legally using a computer and the internet and then breaks the terms of use, whether that term of use is written by Apple, whether it's written by Spotify, whether it's written by Twitter, whether it's written by your employer or the government. If you break any of those terms of use, which we know what those are, you scroll, you click, I agree, you never read any of it, then you are now subject to potential criminal prosecution. Meaning, one example is our president, who has violated Twitter over and over, could, under the 11th Circuit's interpretation, be prosecuted criminally, because he has authorized use to use Twitter and then is breaking their terms of service. And so there has to be something more. This is clearly written and considered by Congress as they wrote it, and they had language that they then rejected. They considered this and decided this is an anti-hacking statute. If you leave it the way the 11th Circuit is interpreting it, then it becomes a statute that makes criminal anything that prosecutors want to criminalize. And that's not a world we can live in, because as we've seen over and over in the history of this country, prosecutors will use the law for many improper purposes, to either exact their own agenda, to exact the agenda of their political party, as we have seen in this administration. For example, certain people who have been convicted of crimes who were serving sentences during COVID have been released because they were friends of the president, right? That is selective prosecution. That's selective enforcement of a statute.
You're criticizing our president? Oh my goodness.
That is a world in which there is no rule of law, because the rule becomes, I am the law is me, and whatever I decide will be what's enforced. And you also end up in a situation, and I talked about this last time, where the way the federal government prosecutes crime is to throw a net as largely as it can, grab as many people as it can, and then bully them into flipping. And when you can take any person, and I mean any person in this country who uses the internet, and you could go through their internet search history and find probably dozens of examples per day, if not per hour, in which they are misusing the terms of what they signed up for this device for. Whether it is, and the great examples are, you sign up for an online dating site and you misstate your height or your body shape or your interests, or you are using your computer at work and the internet at work to fill out your March Madness brackets, right? These are all prohibited uses. The federal government could take any of us and now threaten to charge us with a crime and say, if you don't do as I say, I will not only charge you, but I will prosecute you and I will put you in jail. And now you have to work for me, right? It is a free pass for the government to take any of us and make us into unwitting cooperators, which we call flippers, rats, whatever you want to say. And they can just willy-nilly use this because every one of us, as we sit here, is in violation of this statute, the way the 11th Circuit is reading it. The sort of conduct that the defendant did here is both commonplace, and if it is illegal, it is dealt with by existing statutes. For example, the police do have access, as correctly noted in one of the amicus briefs, to enormous data that is personal and private that most people don't have access to, whether it's being able to run people's fingerprints and see prior arrest history, whether it's running license plates, whether it is doing a criminal record search outside of their own jurisdiction, reaching the FBI database, reaching Interpol. There's all sorts of data that is private and that is properly only within the purview of the government. And many law enforcement have access to this. But if they use that improperly, if they sell that to someone, there are already statutes, both civil and criminal, in place to deal with that conduct, right? That conduct is not in danger of running amok and becoming a lawless situation, because that's something the lawmakers thought about and said, whether or not they're computers, the police are not allowed to go and find your fingerprints and sell them on the black market, right? We don't need the age of the internet to decide that this is conduct we want to prohibit, and it has been prohibited.
Priya,
yes. Mm-hmm.
I'm sorry, you're sort of answering the burning question that I had in my mind, which I think you're answering it, which is, it sounds like, for what happened, that there was a crime committed, and it sounds like perhaps, and I don't want to put words in your mouth, is it there was a crime committed, but they're citing the wrong statute to try to prosecute and bring it to light? Yes, a crime, wrong law that they're citing. Am I understanding that correctly?
That is part of what I'm saying. I'm saying that you cannot call misuse a crime. You have to very narrowly say what the crime is so that people can understand what they're doing. Most people would understand that if they're going onto a computer and paying for access to child pornography, they're committing a crime. Most people wouldn't understand that if they go onto a computer and check sports scores and then call their bookie and make a bet, that checking sports scores may have been in violation of your company's policy, and now that's a crime. So making that bet, accessing the child pornography, that is a separate crime that law enforcement is equipped with both the statutes and the means of prosecuting. But this is a backdoor way to use a statute that wasn't intended for this. I mean, statutes cannot be willy-nilly chosen to do something they weren't intended to. They cannot be read broadly. They cannot be expanded to, like the definition of obscenity. I know it when I see it. We can't live in a world like that where law enforcement or the current people in power who are directing law enforcement decide what makes this a crime today, because then we end up in a situation where the prevailing political party is the one who's enforcing it in the way that they want to, and that suits them. And that is just a total disruption of law and society. There are statutes in place that prohibit all of the conduct that the government is worried about and that are actually crimes, right? The government would have you read the statute to make lying about your weight on a dating website a crime. And that can't be a world in which we live, because that isn't a crime. It's not something people want to be a crime. It's not something they understand as a crime. It's not something that they had their Congress people go and discuss and make a crime. These are common day behaviors of every person. And criminal law has to be narrowly interpreted. And one of the rules of interpretation is something called, there's two rules that are important. One is the rule of lenity. The rule of lenity basically says that for criminal defendants, when there's one way of interpreting a statute that makes what they did a crime, and there's an equal other interpretation that makes what they did not a crime, then it has to be in favor of the defendant. The coin toss always should come out in favor of the defendant. And this statute can be interpreted, if it can be, in two ways, and the coin toss should always come out in favor of the defendant. And in fact, that is for those of you who were interested in the online gambling, the question of whether poker was a game of luck or a game of chance is what the whole litigation about whether it's a crime to play poker online was. And Judge Weinstein, the absolute genius in the federal court in Brooklyn, did this very long, lengthy opinion about poker and how the hands are played and when you make this bet and when you make that bet. And in the end, what he came down to after, I think, a several hundred-page opinion was it might be a game of chance and it might be a game of luck. And therefore, it's the rule of lenity that decides, and the defendant wins. And that's one very important thing here, right? There's an interpretation that the defendant wins, and therefore the defendant should win, and it shouldn't be a criminal conduct. And the second construction is reading it the way the government suggests runs afoul of other constitutional provisions, such as First Amendment concerns. There are lots of reasons people can legitimately violate the terms of the computer program or internet access that they have that are protected constitutionally. Whether it's research, and there's the great example of, for example, we've seen over and over that social scientists will take the exact same resume and change the name to make it appear to be a Black woman versus a white male with the exact same everything except the name, and they post them on sites like Ladder or LinkedIn, and then they track to see what sort of response it gets. Now, technically, they're violating the terms of everyone, right? The employers receiving them said this has to be truthful. Those platforms said it has to be truthful, but they did it. And this resulted in enormous data that is valuable to society. But this would be a crime. And all of this
Your Honor, can I jump in for a moment?
Yes.
I'm sorry.
And I just like that you called me Your Honor. But maybe you're not talking to me.
Get a word in edgewise at some point.
Go ahead, John. Say something.
I'll just make a couple points. Number one, the statute is very clear. It says whoever intentionally accesses a computer without authorization or exceeds authorized access. And, Priya talks about how that might be unconstitutional or, overly broad. I don't think so. I think it's just as clear as, if you're a security guard, you may have keys to a business, and that may entitle you to unlock the door and go in and make sure there's no intruders. But that doesn't mean you can go empty the cash register. We make all kinds of laws where it says, okay, you're allowed to access something for one purpose but not for another purpose. So, from that standpoint, I don't think we have an issue. The other thing is the rule that Priya would suggest, that it's purely for hacking, right? It's purely unauthorized. Well, first she's reading out words of the statute, which you're not supposed to do when you're interpreting a statute. But more than that, she would, and the position of the petitioner would say that the only way that the CFAA can be invoked to basically put teeth in a security regime is if you have effectively password protection and somebody breaches a password. But that's not realistic. That's not the way that business is done. That's not the way that organizations operate. You have policy handbooks that say even if you have practical access to the data, we have rules for what you can do with it and the purposes for you to access it. And I'm afraid that if Priya's view of the world prevails, she's actually giving a green light to every dirty cop in America to use these incredibly powerful and comprehensive databases for whatever purpose they want, whatever dirty, nefarious purpose they want. And it actually surprises me that Priya would come out so strongly in favor of dirty cops. Priya, go ahead.
Wow. So
shots fired. Who you calling dirty, man? Who you calling dirty? Come on. I'm not dirty.
So I think dirty is in the eye of the beholder, right? So first, the statute was written, they chose their words carefully. There are other statutes that have the language that the government wishes was present here. But it isn't. We are here to interpret this statute as it is written. If Congress intends to make this broader and not an anti-hacking statute, then they can go back and rewrite it. But that does not change the facts of this case, which have to be interpreted under the statute as is currently
right.
written.
But the unintended consequence of this case right here is the rewriting of CFAA in court versus Congress actually doing that. So when dealing with this issue right here, right, we have somebody who had access to a system for lawful use, used it for an unlawful use, and now the government is saying, well, wait a minute, it's a CFAA abuse violation. It's the same thing as saying, you go onto a dating website and dating website says, well, you have to, everything you have to put in is factual for us to be able to do our job. But you say you're 6'5" when actually you're 4'5", right? Isn't that a breach of CFAA?
So the government's argument would have you believe it is. And this is the problem. I'm not suggesting the statute be rewritten. I'm suggesting that the court look at the words of the statute, use traditional statutory interpretation, which means you have to look at the plain meaning, look at the legislative history, which shows that words they struck out in prior versions, and look at comparable statutes that use the words that the government wishes were here right now. This is an anti-hacking statute. It cannot be read to be something more, because then it does criminalize everyday behavior by everyone. And, the government's response that, but you can trust us not to apply it too broadly or too generally, that can never stand. We cannot give the to use a metaphor here, we cannot give the prisoners the keys to the prison, right? We cannot have the government decide what the law is and when it gets applied. That's the whole purpose of the Constitution. Actually, the job of the criminal defense lawyers is to enforce the Constitution. The job of law enforcement is to enforce the law as they see it. But then this court's job is to look at this statute, decide what it means, what it prohibits, and whether this person who was convicted should have been convicted under this statute, under the fair interpretation of this statute. And this statute, as it's written at this time, does not prohibit this behavior. There are other statutes, and to John's point of, am I encouraging police to law enforcement to abuse their access? Absolutely not. And there are countless statutes, both civil and criminal, that prohibit law enforcement from abusing their access to this. Up and down every layer of government, these things exist. Every law enforcement personnel who has access, from secretaries to the head of the FBI, has to make promises and agree to be subject to criminal prosecution if they violate that. So there's no world in which the interpretation that we are suggesting, which is the right one, results in a parade of horribles where law enforcement is now on eBay selling people's criminal histories. That is never going to happen. This statute is not necessary to achieve that. That is already in place. This statute was, to the security guard example, the security guard has certain keys. That guard cannot then jimmy a lock he does not have the keys for. That's what the statute is. It is to say there is a wall that you are not allowed to penetrate, and you penetrated it. Not that you were allowed to penetrate it and then you did something improper or illegal. If it was improper, then it's just not illegal, right? Misstating your height is improper, but it's not illegal. Criminal law makes things illegal.
What about weight?
Oh, that should be illegal. I agree. That's just not right.
So I got to jump in.
Problem
I got to
here.
jump in here for a second because in the briefing, the U.S. government sort of tries to make a fine distinction, and people can decide if it's persuasive or not, between computer systems where somebody affirmatively gives you access and entrusts you with access, as in a law enforcement database, and one where you just kind of sign up and click on the terms of service, and they're trying to say that those are different situations. I'm not going to get into that argument because it's kind of boring. I'm going to take actually the more aggressive position and say that you should be able to be prosecuted for violating terms of service in some cases. And I'm going to be interested to see how Priya responds to this, because there's a case that happened about a decade ago. And I'll quickly give you the facts of the case. Mom has a daughter who the daughter's friends are spreading nasty rumors about her. And so mom decides to get back at the daughter's friend or acquaintance who is spreading these noxious rumors by setting up a MySpace account. So that'll tell you when this happened. Mom set up a MySpace account, gave a false name and made a false profile that this is as if she was a 16-year-old boy flirting with this girl. Okay, and the mom basically catfishes this young girl. This goes on over the course of a month or two, and the girl becomes infatuated with what she thought was this boy that was paying wonderful attention to her. Okay. And then suddenly the mom turns on her and, using the boy as a sock puppet, turns on her and becomes abusive, and eventually suggests that the world would be a better place if this poor girl wasn't in it. And the girl committed suicide. And the feds came in and saw what happened and saw that this awful mother had, created a fraudulent MySpace account, used it to torment a young girl to the point of suicide. And they charged this mother under the CFAA, saying that she had accessed MySpace under false pretenses, and that was a violation of CFAA. And so I guess the question I would have for Priya is, shouldn't that mother go to jail?
Only if the conduct that she engaged in was an existing crime at the time she engaged in it. What the government did there and is seeking to do here is they don't like behavior, and they can't find a statute that criminalizes it. And then they realize maybe there is no statute. And so then they try to find another statute and shove the facts of this into that statute and make a crime. And
so
the government
let me step in
yes.
here. Is that a form of cyberbullying by the U.S. government?
I mean, almost everything the government does is bullying. So it depends on the platform. But yes, it is. There's a law called ex post facto, which means the thing had to be a crime at the time I did it. You can't write the law tomorrow and then criminalize my behavior yesterday. And what this mom did, it could be that it was completely legal. It might be disgusting, but there might not have been an existing criminal statute to encapsulate that. And this is how, war games or whatever, this is how hacking became a crime, because as John correctly said, it rose to the level of consciousness of the old people in Congress who understood this thing is happening. We should do something about it so we can stop future behavior. Whenever there's innovation in society, and that happens at every level, there's going to be conduct that might not be at that moment criminal conduct. And that is up to society and the legislature to decide, you did that. We don't like that. We're going to discuss whether or not we should make that an actual crime and what the penalty should be, and go through the legislative process. And as of today, that is no longer allowed, but you did it yesterday. And therefore, there's no way to criminalize it because this law happened after the fact. So in the case that John gave, and this is one of the government's favorite instruments to play of, isn't this terrible and isn't it a tragedy? Sure, but laws are not written by tragedy. Law is written by Congress and then interpreted by courts to decide, is that law constitutionally valid? Should it be applied the way it is being applied? And in that case, I think it was an extreme overreach. And in this case, it is the same thing, that if the question was asked, who should be rewriting the law? Definitely not the Supreme Court. The Supreme Court doesn't have that power. The Supreme Court can only look at the words of the statute, the way it was applied, the Constitution, principles of law that exist as we sit here, and say, does the law as written, as reasonably interpreted, prohibit the conduct that happened? And if the Supreme Court says, actually, what Officer Van Buren did may be disgusting, it may violate other laws, but it didn't violate the law you tried to prosecute him with, then the system has worked, because then Congress has the message. The Supreme Court has written a note saying what happened was not a crime as you wrote this law. So it's up to you to decide, because we are not the law writers. And Congress will then go back and say, you know what, we do want to criminalize this behavior, and then ends up a robust debate where people who are in the know and in the weeds get to be heard and get to explain how, whether lying about your weight matters and whether it matters in a criminal way or in a civil way. And then arguments like John's of certain things he believes should be a crime. Well, let's hear what those are. But we can't just blanket say, if you do something that this platform doesn't allow, it can be a crime. That's not what this was meant to do. So that's my answer to that question. And as for law enforcement and people with access to systems using them for improper purposes, that's something else that happens absolutely every day, 1,000 times a second. And people who are, for example, I say this with knowledge without confessing anything, but people in public defenders' offices also have access to criminal records and databases, or many of them do. And it is a routine thing that when someone begins dating someone new, they run a quick criminal history check on them just to see what the background of this person is. And that is not something that is done for monetary gain. It is not publicized. It is not done to embarrass or reveal any public information about that individual, but strictly it is an improper use. And this is something that is done not just in public defender's offices, but in prosecutors' offices, in police departments. If you hire an investigator in almost any case, there is a good chance that investigator is an ex-officer. And a lot of that investigator's methods involve the relationships they still have at their former office, whether it's an FBI office or a police department office. And often the most effective investigators are people who are able to call in a favor and find out, is there an outstanding warrant, right? That is not information that should be given out, but that is happening thousands and thousands and thousands of times a day on every level, whether it's for personal curiosity, whether it's for, one example in the briefing given, law students get free Westlaw access. That's so that they can learn how to do legal research. There's probably not a law student alive who didn't use that Westlaw just for their own personal, whether it was interest or benefit in some way, doing research on a statute that they need in their own life. So these things are happening all the time, and they're commonplace, and they're not considered crimes. If the lawmakers want to make specific categories of those crimes, they should hear robust debate on why, which categories, and then narrowly carve out those categories. Obviously, the ones that are harming people in some definable way that lawmakers and the people who vote for them agree that this is a harm we want to contain, those things should go through. Those things should become law. But as we sit here, this law is written is not that, and it cannot become that because we don't like the behavior.
Well, but Priya, if I may just jump in for a moment, we all know that the government and intelligence agencies have enormous databases. Some have said that it collects every email ever sent. I don't know that for a fact, but I've heard that.
Right, but databases are analogous to this situation. What is the crux is, could he access the data to make a profit off of it outside of his jurisdiction, right?
That's one issue, but I would put it to the security and compliance guys. If the rule is that the only way you can be prosecuted under CFAA is if you hack into something, breach a password or something, and that insider threats or inside misuse of the data is not a crime under CFAA, then you're in a position where you have
no, hold on,
item basis.
Objection, complete objection. Josh, go for it.
Go ahead.
So Weave was prosecuted for exactly that. Just in,
yes.
I've been holding my tongue because I'm supposed to be the police guy in this trial weirdness. But realistically,
ask questions later. Go ahead.
Who was prosecuted?
Weave was prosecuted for specifically not hacking anything, but for simply retrieving information from a system that he was authorized to be on because it was public. So this I don't mean to be rude, but that whole concept that even Priya mentioned that you have to hack in to be prosecuted for this. No, try again. He simply typed in.
The question, though, is how to interpret the law. Right?
Yes. And they've interpreted it that simply accessing information that is publicly accessible is a violation of the CFAA.
Right. So even if it's publicly accessible, in this case, it's not publicly accessible. Right.
Oh, yeah.
So ergo.
Well, when I became a police officer, this is many, many years ago. We're now talking, 2002. But they had me sign a raft of paperwork and took me in to see the NCIC terminal, National Criminal Information Center terminal, which was like hidden behind 5 locked doors. You had to find it and navigate to it and have keys for all the doors and get in. And I walk in and I'm like, where's the terminal? They're like, oh, that's it. I'm like, no, it's not. They're like, what do you mean? No, it's not. That's the terminal. I'm like, and if you recall, if you were around in that time period, remember all the crap that would pop up on your screen if you had a broadband connection, all the windows, all the cruft that would just show up. This thing was full of it. Like you literally had to close 100 windows to get to the VICAP and the NCIC application. And I'm like, no, this is just a straight internet terminal. They're like, well, yeah, that's it. I'm like, no, that means that that any computer is now the NCIC terminal. Like, no, this is the only one that's allowed on. I'm like, y'all are stupid, but okay, whatever. Those are public, or they were at least public web applications.
Yeah,
Hey, I want to shift gears a little bit. Well, I'm sorry, Priya, if you have a response.
So I do have a response. This idea, that John keeps throwing out as, things have to be password protected. That is what we're saying. I mean, we are in the world of computers that have evolved. There were times when companies, whether they were hospitals or financial institutions, started using computers and had no passwords in place, same as having a bank with no vault, right? And they had to learn, here's how in the world of computers, and this is why part of you guys exist, how do you keep things safe, right? What do you use in the computer world as a vault, as a lock, as all those hundreds of doors that were just described? And there's a concept in law that law enforcement gets to use all the time called in plain view. If the government can see it and you did not bother to hide it, you invite them into your house, or they're here for a search warrant, and you have left your pounds of cocaine and weapons in plain view, then sorry, they've seen it and they can do whatever they want with it. And there is a similar concept we're using here, in that if you have let someone in and you have left everything exposed and you say, walk through this room, but close your eyes when you get over here, that's not realistic. You do have a responsibility, if you are going to limit access to someone, of making some sort of barrier. And in a physical building, we understand, right? We all go to museums, we see the exhibits, and then there are doors that we're not allowed to go through, right? And there's probably the coolest stuff back there, but we're not allowed, right?
Oops.
And this is the same thing.
Priya, that actually, you're bringing up something I wanted to ask early on. So your analogy just now with the museums, and there's areas that are more or less clearly marked off limits. What if the door's not locked? Or what if the door is wide open? Is it still a crime to enter?
So the question is, did you enter or did you just look, right? If the door is wide open, you can just stand on the outside and look. So breaking and entering, which is the analogy used here, is typically a state crime. It's not a federal crime. But in New York, what it means is that if someone's window is open and you poke your hand through their window, right? You haven't touched anything. You're now just sort of inside the windowsill. You have broken and entered. And that's enough for the action to happen. But if you just stand in front of someone's apartment and you look through their open window, sorry, that would be my dog chiming in.
I was about to say, I feel the same way.
He thinks someone is breaking and entering here because they've rung the doorbell.
But they rang the doorbell, so
right. So you need a security provision like this to tell the likes of Amazon, how dare you show up.
Right.
There is something more. If you've left your doors and windows wide open, you cannot prosecute people for looking, but you can still maintain a boundary if it is something that's understandable. People's homes, you understand you cannot walk in even though the door is open, but you can look in, right? Because they have not taken any precautions to protect their privacy. And it would be the same here. If the museum left the door open, but had a sign that said, do not enter, you could not enter, but they can't prosecute you for looking, because if they really wanted you not to look, they would shut the door.
I think most of us would have said, hold on, I need to go yell at the dog.
We'll talk amongst ourselves while the dog is taken care of. We actually need to start winding down here. I want to take Jeff's
analogy, though, because what Jeff was saying was, you go into you buy a ticket to go to a museum, okay? You have a license to enter the public portions of the museum. You now see a door, right? And the door says employees only, do not enter, right? But then you grab the doorknob and you open it and you realize it's unlocked. So under the CFAA, as the 11th Circuit held, in that case, in that metaphor, you could be prosecuted under the CFAA for entering that unauthorized area, even if the door wasn't locked. And the position that Priya, I think, is asserting is that if there isn't a lock on the door,
objection, argumentative, requires speculation. I watch too much Law and Order. Hey, we need to wrap up here. I want to just offer Priya and John an opportunity for very brief closing statements, but really just two-part question, and this will be our final thoughts. What do you think is going to happen in terms of the Supreme Court ruling, and what do you think should happen if they happen to be different? Let's see. I think we start with John.
Fifth of whiskey. This is live. Just FYI.
Sure. Yeah, the defendant gets to go last, so I'll be very brief. My suspicion is that they're going to try to rule very narrowly on the facts, and that they're going to attempt to create a rule that enables you to prosecute in the case of if you're given access to some super sophisticated database, but then carve out the the dating site analogy, and that's going to be. We'll see how successfully they're able to do that. But that would be my suspicion. I don't think they're going to make a broad ruling that says that CFAA only applies to unauthorized access. But you also can't have the situation where if you say you're 6'4" and you're really 6'2", that's a federal crime.
Okay, Priya. Final thoughts. What do you think is going to happen in terms of outcome, and what do you think should happen if that happens to be different?
What will happen just will depend on the composition of the court, honestly, because if the more conservative this court gets, it basically says the law is as the people in charge decide, which is, I don't think, very fair. What I think should happen is that this statute should be interpreted the way it's written, and the court should say under these facts, because this person did not access this data in an unauthorized way, that is a material element of the crime, and it was not satisfied. And so then the court should instruct Congress that if they want to rewrite the law by eliminating that element or being more clear on what the elements are, then they can do that. But I don't think they should uphold this conviction. So the short answer is this conviction should be reversed.
Interesting. And I'll squeeze in one last question because you did touch on it. I was curious, Priya, if you thought this was a case that was going to be one of these 4-4 currently as the court sits decisions right now, or is it going to be a 5-4 type of decision, or is it a no-brainer, clear majority type of decision? I think you answered it. You said it's probably more likely going to be a 5-4 type of decision. Yeah,
I think that the way the more conservative, as they're called now, justices interpret statutes, the trend in it will make this a 5-4 decision.
Yeah. Fascinating.
I would just only add that it's interesting.
But I haven't given you permission to add,
yep.
John.
What's that? Oh, go ahead.
I haven't given you permission. No, I'm sorry, but I was going to let Priya have the last word. We do need to wrap. Priya, thank you so much for joining us again, and hopefully we'll find some other lame excuse to bring you back on again, because we certainly enjoy every time that you come on.
Oh yeah.
That's going to wrap us for today. Yeah. Court is adjourned, and we'll talk to you next week.